welcome. Welcome to 60 years later, the Alaska Constitution, History and Context, symposium sponsored by the UAA Justice Center, the Alaska Law Review out of Duke Law School, and also in association with the Historians Committee of the Alaska Bar Association. This is our third symposium that we've hosted. So as many of you know, I'm sure the Alaska Law Review, there's no law school in Alaska, so the Alaska Law Review is published out of Duke University, and every year wonderful Duke Law School students come up to visit Alaska to solicit ideas for articles, and we decided with Professor Tom Metzloff, who's the advisor, a few years back to start doing a symposium to help present emerging research to the Alaska legal audience. And so our first symposium was in 2014 on the future of economic development in Alaska with a changing climate. Then 2 years ago we did a symposium on the 45th anniversary of the Alaska Native Claims Settlement Act and challenges going forward. And so when we were thinking about this year's symposium, we always try to come up with topical topics, and we realized, hey, you know, January 3rd, 2019 is the 60th anniversary of Alaska's statehood, so we figured, you know, close enough we should do something on the 60th anniversary of the Alaska Constitution. Do a little research, turns out that the Constitution was actually drafted in 1955. There were 55 delegates to mirror the 55 delegates at the drafting of the U.S. Constitution in Philadelphia in 1787. They met up at the University of Alaska up in Fairbanks for 75 days from November 8th to February 5th of 1956. You know, why they chose the coldest months to meet in Fairbanks, I'm not sure. But they came up with a great Constitution we're going to be spending today talking about, and the Constitution was ratified by territorial voters on April 24th, 1956. Statehood wouldn't be for another couple years, and as I said, Alaska was admitted to a state on January 3rd, so you know, maybe arguably we should have held this symposium a couple years ago, but considering statehood, I ask you, what is really the true anniversary of the Alaska Constitution? We're excited to have some wonderful panelists. We're going to be starting with an absolutely amazing keynote speaker, Dean Erwin Chemerinsky, Dean of the UC Berkeley Law School. He's been there since July of last year. A very distinguished career. Before that, he was the founding dean and professor of First Amendment law at UC Irvine. He's been a professor of law and political science at Duke. And also a law professor at USC. He's the author of several prominent books, including two completely different and very prominent constitutional law textbooks. I guess you have different flavors of how you like to study constitutional law. Same for criminal procedure. His most recent books are The Case Against the Supreme Court from 2014, Closing the Courthouse Doors, How Your Constitutional Rights Became Unenforceable from 2017, and then Free Speech on Campus, also from 2017, which he wrote with Howard Gilman. And by the way, I'll also mention, if you decide you can't get enough of Erwin, which, you know, who can't, he's speaking again over the lunch hour at noon. There's an event over in the Fine Arts Building in room 150 starting at 11 to 1 on campus free speech, starting with a debate with the Seawolf debate team, and then a speech by Dean Chemerinsky at noon. Now, we of course want you to stay for our event, and I will note for those of you that are attorneys, their event is not approved for CLE credit, ours is, so you know, just keep that in mind. So very distinguished career, constitutional scholar, which you may say, great, but you know, why is he up here talking about the Alaska Constitution? Well, again, as those of you who are attorneys in the audience probably know, he comes up every year to the Alaska Bar Convention without fail. He presents an overview of some of the more prominent U.S. Supreme Court cases. But not only that, he also presents selected Alaska Supreme Court cases. And so, you know, he has to review these cases. He knows the history and development of Alaska constitutional law, including the uniqueness of the Alaska Constitution in protecting rights and liberties. And that's what he's going to be speaking to you about today. Thank you.
Thank you so much for the kind introduction. It's truly a great honor and pleasure for me to be here. I've been a law professor for a long time now, 39 years. I've never seen my law students as despondent as in the last couple of weeks following the Senate Judiciary Committee hearings and the confirmation of Brett Kavanaugh. So I decided that it would be useful to convene a faculty panel to allow some of my colleagues to share their thoughts with the students. Because of room availability, I could get the largest room in the law school only on Friday from 12 to 1. Any of you who know law students, or remember being a law student, know Friday afternoon isn't the best time to get people to attend an event. To my surprise, not only was every seat taken, but every space on the floor and on the steps was taken by people sitting. The back of the room was filled with people standing. I had to begin by asking the students to do me a favor and for no one to call the fire marshals. I had 4 colleagues, each offered their thoughts. I just said, say whatever you want at this moment in time. And I offered my thoughts. And I said to the students that it's likely to be a very conservative Supreme Court now for years and maybe decades to come. And I said that I really think that we have only 2 choices in light of that. And that's to either give up or to fight harder. And that, of course, means there's only one choice, that we're going to have to fight harder and better than we ever have before. And I then wanted to talk with them about how they can do that. And I said one key way is to increasingly turn to state constitutions and state courts. In the face of a Supreme Court that is likely to be inhospitable to individual rights, as I say, for years or decades, there is an alternative forum where successes often be had. This is not a new insight. In 1977, William Brennan wrote a famous article in the Harvard Law Review urging increasing use of state constitutional law. I'm sure part of why he said this was that he himself had been a justice on the Jersey Supreme Court before going to the nation's highest court. But it was clear that he was feeling despondent at that moment in time as he saw a Supreme Court that had become more conservative in 1969 with the first 2 Nixon appointees, even more conservative in 1971 with 2 more Nixon appointees. So he is trying to point a way for the future for a greater expansion of rights and equality. It seems especially appropriate to be talking about reliance on state constitutions today when just yesterday the Washington State Supreme Court found that the death penalty in that state was unconstitutional as a violation of the Washington State Constitution. Of course, Alaska eliminated the death penalty back in 1957, far before we're talking about what's happening today in the United States. So I decided that what I wanted to talk about this morning is the use of state constitutions and state courts to protect liberties. As was mentioned, I have a special relationship to Alaska. It's a very important part of my professional life. It came about, as so many things do, in an unplanned way. In 1990, then Chief Justice Jay Rabinowitz invited me and a law professor from UCLA, Peter Arenella, to come up and speak at a conference of state Supreme Court justices of 5 states. It was going to be held in Glacier Bay, which is one of the prettiest places that I've ever seen. And Chief Justice Rabinowitz liked what he heard enough to invite us to come the next year, in 1991, to speak to the State Bar Convention. And I've returned every year since 1991 to do that. About 15 years ago, I was asked, in addition to doing a review of United States Supreme Court decisions, would I talk about Alaska Supreme Court and Alaska Court of Appeals decisions dealing with constitutional law and criminal procedure. Agreed to do that and have done that every year since. I will tell you in all candor, of all of the talks that I'm fortunate enough each year to do, it is by far the hardest. Some of it is that in order to choose the cases, I need to read all of the decisions of the Alaska Supreme Court and the Alaska Court of Appeals dealing with constitutional law and criminal procedure. And there are a lot of them each year. Your courts have extremely large dockets. Some of it also is, I'm reading this as an outsider, and I'm speaking to the judges who decided the cases and the lawyers who argued them. No matter how carefully I read them, I don't know things that are not in the published opinions. I don't have the opportunity to read the record or the briefs. It's also particularly difficult because I learned that they don't want me to simply come up and summarize their cases for them. They know what they argued and they decided. What they want is my analysis of the cases. But there's inevitably something uncomfortable but criticizing decisions with the judges sitting there or with the lawyers who argued them present in the room. In fact, it's even become more uncomfortable as each year I've come to realize that the judges actually worry about what I'm going to say. I mean, why should they care what this law firm is going to say? But I've had several of the justices over the years say they're always nervous to, and I'm very gentle, and Alaska has truly superb judges on its Supreme Court and Court of Appeals, so it's not as if I'm ever giving a scathing critique. But the result of that is I've come to know Alaska constitutional law far better than any other state's constitutional law, including the state where I've been for most of my professional career, California. I thought I would address 3 questions this morning. First, why is it that Alaska has developed such a robust body of constitutional law? Second, what is this most likely to mean for the future as we look ahead to what's going to happen in the United States Supreme Court in the years, maybe the decades to come? Where will Alaska constitutional law make the most difference? And third, I have to talk about what are the limits of state constitutional law. I once wrote a law review article titled 2 Cheers for State Constitutional Law, and I still believe that. And so I think it's important to put all of the praise of state constitutional law in a larger context that also recognizes its limitations. So as to the first question, why has Alaska developed such a robust body of state constitutional law? It's easy to give simple answers. There's something very independent about the spirit of Alaska, and it's been there since the very beginning. Some of it is that the tradition of developing Alaska constitutional law, apart from United States constitutional law, started very early in its history. For example, just pick a small illustration. In Gilbert versus United States in 1967, the Supreme Court said it does not violate the Fifth Amendment privilege against self-incrimination for the police to require a person who's not represented by counsel to provide a handwriting sample. The Supreme Court said the Fifth Amendment prohibits people from to give testimony against themselves. The handwriting sample isn't testimonial. But just 2 years after that, in 1969, the Alaska Supreme Court in Roberts versus State came to the opposite conclusion and said on the Alaska Constitution, this is impermissible. Well, this is just one example from relatively early in Alaska history. I can give so many other examples, starting with the very beginning of statehood. But to say that there's an independent spirit or to say that there's a tradition, I don't think fully explains how did it come to be here in Alaska. And I would say among the states in the country, Alaska has among the most robust separate state constitutional law. Why is that? Well, I can come up with a couple of explanations, and they're interdependent. One is the difference in the text of the Alaska Constitution compared to the United States Constitution. And I think specific textual provisions have understandably led to greater protection of rights. Now, I've long believed and tried to teach my students that any constitution is very much a function of the time in which it's written. If we were to write a constitution today for the United States, it wouldn't include anything like the Third Amendment. I'm not going to try to do a survey of how many of you know what the Third Amendment is. The Third Amendment says that the government can't require that a person quarter soldiers in his or her home. But in 1787, that was included because the King of England had a practice of requiring people to quarter soldiers in their homes. Likewise, there's things in the Alaska Constitution that are very much a function of the time in which it was written. Let me give you an easy illustration of this. It's found in Article 1, Section 7 of the Alaska Constitution. It says, "The right of all persons to fair and just treatment in the course of legislative and executive investigations shall not be infringed." Remember when the Alaska Constitution was written in the mid-1950s. It was just following, and not completely after, the McCarthy era, a time when people were subjected to what can only be described as harassment, forced waiver of the privilege against self-incrimination in legislative and executive proceedings. It's notable in talking about the text of the Alaska Constitution how it's Article 1 of the Alaska Constitution that contains the Declaration of Rights. Article 1 of the Alaska Constitution, I think, is quite appropriately and symbolically the place where they put the Statement of Individual Liberties. In the U.S. Constitution, Article 1 is about the legislative power. Article 2 is about the executive power. Article 3 is about the judicial power. There's very little in the text of the United States Constitution about individual liberties. That's why so many states insisted on a Bill of Rights, and it was added 4 years later in 1791. But it's not just Article 1 of the Alaska Constitution that provides the Declaration of Rights. There are protection of rights found in other places of the text of the Alaska Constitution as well. Article 5 has provisions with regard to voting rights. Article 6 deals with issues with regard to legislative apportionment. Article 7, that I want to come back and talk about, talks about obligations of the state with regard to health, education, and welfare. Article 8 includes the duty of the state to protect natural resources. It includes within the text the obligation of the state to protect public trust. So many of these articles of the Alaska Constitution have provisions that have no analog in the United States Constitution. Some were added later. Article 1, Section 22 of the Alaska Constitution protects a right to privacy. As you know, there is no analogous provision in the United States Constitution that protects the right to privacy. Privacy is a word that's not mentioned in the United States Constitution. One of the first Supreme Court cases to find that there's privacy protected under the liberty of the Due Process Clause was Griswold versus Connecticut in 1965. And actually what Justice Douglas did there was say that privacy is protected by the penumbra of the Bill of Rights. He said there's privacy aspects of the First Amendment, the Third Amendment, the Fourth Amendment, and the Fifth Amendment. One commentator said at the time that Douglas was like a cheerleader skipping through the Bill of Rights, saying, give me a P, give me an R, give me an I, and it found privacy in emanations. I've always thought that it created a very shaky foundation for privacy under the United States Constitution. And I think that it will have effects in the longer term as the Supreme Court undermines privacy rights under the United States Constitution. But privacy is right in the Alaska Constitution, and that has enormous significance. Again, just to pick one example, in People versus Raven, back in 1975, the Alaska Supreme Court found that under the right to privacy, there's the right to possess small amounts of marijuana for personal use in one's home. It doesn't include a right to buy or sell marijuana, but it does take the right to privacy in the Alaska Constitution and give it a specific meaning. Now, it took another 40 years for other states to begin to create a right to possess marijuana for personal use. And now a number of states, including California, do that. But Alaska did so, and I think it was key to it that there was the specific provision of the Alaska Constitution. There are other areas where amendments provide rights that have no analog in the U.S. Constitution. Alaska amended its Constitution to provide detailed protection for victims' rights. There's nothing like this in the U.S. Constitution. So if you look at Article 1, Section 24 of the Alaska Constitution, it has a long list of rights that are protected for victims of crimes. The right to be protected from the accused, the right to confer with the prosecution, the right for victims of crime in all court proceedings to be treated with fairness, dignity, and respect, the right of victims of crime to have timely disposition of criminal proceedings, the right to be present, the right to be heard at sentencing or post-conviction proceedings, the right to be there for any release proceedings, a right to restitution, a right to be notified if the convicted criminal has escaped. To say the obvious, there's nothing like that in the U.S. Constitution. But correspondingly, there's provisions in the Alaska Constitution that have been interpreted to create rights for criminal defendants that don't have any analog in the U.S. Constitution. Take, for example, the right to bail. The Eighth Amendment to the United States Constitution says that there cannot be excessive bail. But the Alaska Constitution specifically says that there's a right to bail in all but capital cases. Since there are no capital cases, since there's no death penalty in Alabama, it creates a right to bail much broader than that in the United States Constitution. The Alaska Supreme Court has interpreted language in the Alaska Constitution to create a right for rehabilitation to prisoners. That too has no analog in the United States Constitution and is very much based on the text. Another area where the text of the Alaska Constitution differs from the U.S. Constitution and has major consequences is with regard to affirmative duties of the government that are created. It's often been said that the United States Constitution is about negative liberties, prohibitions on what the government can do. The United States Supreme Court has famously, on many occasions, refused to find any affirmative constitutional rights. I think here of San Antonio Board of Education versus Rodriguez in 1973, where the United States Supreme Court held that there is no right to education under the United States Constitution. Or I think of DeShaney versus Winnebago Department of Social Services in 1989, where the Supreme Court held that the government has no duty to protect people from privately inflicted harms. In that case, that the state, despite repeated warnings, had no duty to protect a child from serious abuse by his father. But there are provisions in the Alaska Constitution that create affirmative duties on the part of the government. So with regard to education, if you look at the Alaska Constitution, it specifically says in Article 7, Section 1, that the state has to create a system of public schools that are free from sectarian control. Article 7, Section 4 creates a duty of the state to protect public health. In Section 5, it creates a duty of the state to protect public welfare. As I already alluded to, Article 8 creates specific duties of the state to protect the natural resources of Alaska. And it's obvious, given the beauty and the resources of the state, why that would be there. And the Alaska Constitution creates a duty of the state to protect the resources of the state in public trust. There's a lawsuit pending right now in the state of Oregon in federal court where litigation has been brought on behalf of children, arguing that the United States government has the obligation under the public trust doctrine to deal with the problem of climate change. The federal district court denied the motion to dismiss. The Ninth Circuit has refused an interlocutory review, so the suit proceeds. It's much harder under federal law or the United States Constitution because there's nothing like the public trust doctrine under the United States Constitution, but it exists specifically in the Alaska Constitution. My guess is that if there were a constitutional convention now in 2018, the United States Constitution would look a lot more like the Alaska Constitution than what the United States Constitution was written to be in 1787. Alaska had the tremendous benefits of the experience under the United States Constitution and to include these provisions. But there's no doubt, and I could trace this to each of them, that having this specific language in the Constitution has made an enormous difference in the development of Alaska constitutional law. But having words on paper isn't enough. Often in teaching constitutional law, especially to undergraduates, I would have them read for the first class a copy of the United States Constitution and a copy of the Stalin-era Soviet Constitution. I would also have them read descriptions like Solzhenitsyn of life in the gulags. And I'd always ask them, what's the difference? I mean, they would be surprised that the Stalin-era Soviet Constitution had a much more elaborate statement of rights than the US Constitution, and yet, unquestionably, much more in the way of abuses. And a key part of that is a tradition of enforcing the Constitution, and that comes down to the judges. And I think that Alaska wouldn't have had this wonderful history of robust state constitutional law just for having the words on paper. Alaska has had, throughout its history, terrific justices and judges. I say to you, I read all the Alaska Supreme Court and Court of Appeals decisions each year, and I'm convinced there's no state that has a finer set of judges now or historically than Alaska has had. I worry about naming names because I'm not going to list everyone who's ever served on the Alaska Supreme Court or Alaska Court of Appeals, but when you think of people like Jay Rabinowitz or Wayne Matthews, Dana Fabe, who served 3 terms as the Chief Justice of the Alaska Supreme Court, David Mannheimer, who's been on the Alaska Court of Appeals since the beginning. These are judges, justices, who are truly among the very best in the United States. But that then raises the question, why has hit Alaska this great tradition of terrific justices and judges? And I think a lot of that is the method of judicial selection here in Alaska. As you know, there's created a commission, and it's got various members who are there, some by the bar, some through other mechanisms. And it has to provide at least several names to the governor for any vacancy on the court, and the governor either has to pick from those names or ask for additional names. And it's the kind of process that explains why a conservative governor like Sarah Palin could pick a judge like Morgan Christen for the Alaska Supreme Court. Morgan Christen, I think, is also one of the finest judges in the country. So relatively briefly on the Alaska Supreme Court, and then President Obama nominated her for the Ninth Circuit, where I think she's among the most respected judges on the Ninth Circuit. In light of what's gone on in Washington in the last few weeks, I think that it would be great if presidents, whether they're Democratic or Republican, copied a form of the Alaska system. It doesn't require a constitutional change or even a statute. A president could simply say, I'm going to create a blue ribbon commission. If it's a Democratic president, it could be 60% Democrats. If it's a Republican president, 60% Republicans. And say, I want you to send me at least 3 names for any vacancy. That it has to be that 2/3 of you approve to these names, so it would have to be somebody with bipartisan support. And I promise to either pick from these names or ask you for additional names. Wouldn't that do a lot to cure the confirmation mess that exists in Washington? I think then we really could move past the very vituperative, increasingly polarized confirmation process that we've seen for the last several decades. And so it would simply be presidents copying what's gone on in Alaska. There's precedent for this, at least at the Court of Appeals level. When Jimmy Carter was president, from 1977 to 1981, he insisted on merit selection panels for Federal Court of Appeals judgeships. He tried to require it for Federal District Court judgeships, but it was less successful in that regard because they've long been regarded as the prerogative of the senators. Jimmy Carter, though, did this for Federal Court of Appeals judgeships, and I think by any measure he appointed some of the most talented and also some of the most diverse Federal Court of Appeals judgeships through this merit selection process. As an example, prior to Jimmy Carter, there were only 2 women who had ever served on a United States Court of Appeals in American history. Jimmy Carter appointed 9 women to the Federal Court of Appeals, among them Ruth Bader Ginsburg to the United States District Court for the District of Columbia, United States Court of Appeals for the District of Columbia Circuit. So I think that when you reflect on what's made Alaska special with regard to constitutional law, some of the text, some of those the individuals, and I think it's the merit selection process of Alaska that's so responsible for that. Well, that brings me to the second question that I wanted to address this morning. Where is it most likely to matter in the years ahead that Alaska has this robust tradition of Alaska constitutional law? I've alluded to in my introduction how we're likely to have a conservative court for some time to come. Think of the age of the justices on the Supreme Court. Clarence Thomas is 70, Samuel Alito is 68, John Roberts is 63, Brett Kavanaugh is 53, Neil Gorsuch is 51. And so reflect that they could easily be together another 10, 15, 20 years as a group. It means that if there's going to be an expansion of rights and equality, it's going to have to be under state constitutional law. But I think it also means that there's going to be areas under United States constitutional law where there's going to be retrenchment from the rights protections there have been, and it's going to require state constitutional law to keep those rights. So let me pick just a few examples where I think Alaska constitutional law will be very important in the years ahead. One of these is with regard to reproductive freedom. I believe we are likely to have 5 justices on the current court who will either explicitly or effectively overrule Roe v. Wade. Since 2010, 33 states have adopted over 400 new laws that restrict abortion. If the Supreme Court upholds these statutes, I think it will largely negate abortion rights in the United States. Even if the court doesn't explicitly overrule Roe, my own sense is there are likely 5 votes to do that. Remember, it was Justice Kennedy who's been instrumental in protecting the right to abortion under the Constitution. In 1992, in Planned Parenthood versus Casey, Justice Kennedy was the 5th vote to reaffirm Roe v. Wade. Just 2 years ago, in 2016, in Whole Women's Health versus Hellerstedt, Justice Kennedy was part of a 5-person majority in a 5-3 decision to strike down a Texas law that would close most facilities in the state where abortions were performed. Since 1992, under Planned Parenthood versus Casey, laws restricting abortion are allowed under the U.S. Constitution so long as they do not create an undue burden on one's right to abortion. But the Alaska Supreme Court provides much more protection for reproductive freedom than the United States Supreme Court has provided. The Alaska Supreme Court initially, in Valley Hospital versus Matsu Coalition for Choice in 1997, said that restrictions on abortion in Alaska need to meet strict scrutiny, need to be necessary to achieve a compelling government purpose. This was the test under Roe v. Wade in 1973, but was abandoned when the undue burden test was adopted instead in 1992. In fact, just 2 years ago, in Planned Parenthood of the Great Northwest versus State, the Alaska Supreme Court reaffirmed that strict scrutiny is used with regard to restrictions on abortion rights. That case involved a state law that required parental notification before a minor's abortion. This is something the United States Supreme Court has long upheld in a series of cases going back to H.L. versus Matheson. But the Alaska Supreme Court struck this down, saying that under the Alaska Constitution, there not only has to be a compelling interest, but any restriction on abortion has to be narrowly tailored. The Alaska Supreme Court found that that requirement failed. So even if the United States Supreme Court comes back on rights of reproductive choice, they're likely to secure under the Alaska Constitution. A second area where the Alaska Constitution provides more protection than the U.S. Constitution that's likely to have significance for the future is free exercise of religion. In Sherwood versus Verner in 1963, the United States Supreme Court said, if the government significantly burdens religion, its action is constitutional under the Free Exercise Clause only if it's necessary to achieve a compelling government purpose. But in 1990, in Employment Division versus Smith, the Supreme Court said, the Free Exercise Clause of the United States Constitution cannot be used to challenge a neutral law of general applicability. if the law is neutral in the sense that it's not motivated by desire to interfere with religion, if it applies to everyone, then there's no basis for free exercise challenge. That case involved an Oregon law prohibiting consumption of peyote, hallucinogenic substance. Native Americans brought a challenge to this, saying the religious rituals required the use of peyote. The Supreme Court upheld the Oregon law and ruled against the Native Americans. Justice Scalia wrote for the court and said, the Oregon law is neutral, wasn't motivated by desire to interfere with religion, it applies to everyone. But the Alaska Supreme Court has made clear that under the Alaska Constitution, any law that substantially burdens religion must meet strict scrutiny. This is so even if it is a neutral law of general applicability. In Frank versus State in 1979, the Supreme Court of Alaska prescribed strict scrutiny for free exercise clause. And even after Employment Division versus Smith and O'Callaghan versus Municipality of Anchorage back in 2002, the court reaffirmed this. The third area where I think Alaska constitutional law is likely to be significant in the years ahead concerns the rights of criminal defendants. I'm teaching criminal procedure this semester at Berkeley, and my students are learning a lot about Alaska criminal procedure. There are so many examples already in the first half of the semester where I'm able to say, this is the rule under the Fourth Amendment, but in Alaska as an example, it's different. I'll give an easy example. Under the U.S. Constitution, the Fourth Amendment, it's not a search if the police go through somebody's garbage. The United States Supreme Court said if somebody's put out the trash, that they have no reasonable expectation of privacy. But the Alaska courts have said there is an expectation of privacy, even when it comes to trash. I could give so many examples of where the Alaska courts have provided more rights for criminal defendants. One that I thought was particularly important from just a couple of years ago is in the area of eyewitness identification. It's a case called Young versus State, and it's from 2016. Many social psychologists, including my former colleague Beth Loftus, have taught us about the fallibility and yet the power in court of eyewitness identification. Social psychologists like Professor Loftus have told us that especially cross-racial eyewitness identification is unreliable. But the social psychologists have also told us that especially given the stress that often occurs in crime, eyewitness identification is very fallible. Yet when somebody before a jury says, that's the person who did it, it had great power. Several years ago, the United States Supreme Court in Perry versus New Hampshire said that all of this evidence doesn't matter and there's only minimal protections with regard to eyewitness identification. That was an 8-1 decision with only Justice Sotomayor dissenting. But the Alaska courts have specifically said there need to be much more protections with regard to eyewitness identification and much more an examination of the suggestiveness of eyewitness identification procedures and the reliability. As I mentioned, there's so many places where there's more rights under the Alaska Constitution with regard to search and seizure than the U.S. Constitution. Just a couple of years ago in Pitka versus State, the Alaska Court of Appeals said that the police can't look at inside closed containers when they arrest somebody who's been driving as part of a search incident or lawful arrest, can't look in closed containers. That's not the law under the United States Constitution. I predict that the conservative Roberts Court is going to cut back on the rights of criminal defendants in many areas. And I think here the greater protections from the Alaska Court of Appeal and the Alaska Supreme Court are going to make a big difference. Now, I have tried intentionally to give a great deal of praise to the Alaska Supreme Court and the Alaska Court of Appeals. There are each year decisions where I disagree, decisions where I think they haven't gone far enough in protecting individual liberties or advancing equality. But my overall evaluation is such an enormously positive one. And yet I think I would be remiss if I didn't address my third question, and that's what are the limits of state constitutional law? There's so much that can be done, as I've tried to describe, but there's also limits on how far it can go. So, for example, state constitutional law is irrelevant where the United States Supreme Court has said there's a constitutional limit that's imposed on the states. Let me give you an easy example here. If the Supreme Court overrules Roe versus Wade, states like California and Alaska can continue to protect reproductive freedom for women. But if the Supreme Court, as I expect that it will hold that all forms of affirmative action violate the United States Constitution, there's then nothing that can be done under state constitutional law to protect a right to affirmative action. If, and I don't think it's likely, but it's possible, the United States Supreme Court will interpret the United States Constitution as saying that the fetus is a person from the moment of conception, and therefore abortion is unconstitutional in the United States, and laws that allow abortion more specifically are unconstitutional because they deny equal protection to fetuses, then there's nothing that state constitutions can do. State constitutions can provide protection where the United States Constitution is the floor where more can be provided. But if the Constitution prohibits something, or federal law is deemed to preempt it, then there's little that state constitutions can do. Second, state constitutional law is inherently inefficient compared to United States constitutional law. To secure a right under state constitutional law requires doing so in all 50 states plus the territories. That requires separate litigation in each. On the other hand, to establish a right under the United States Constitution, you can just take the decision of one court and obviously has great benefits in terms of just the efficiency of litigation. And finally, we have to remember that state constitutional law is often ineffective. There are states like Alaska or Oregon that have a tradition of state constitutional law, who even say the state constitution should be looked at first. But many states in this country don't have a tradition of state constitutional law. And even where there is a tradition of state constitutional law or a willingness to use state constitutions, often states are unwilling to do so. Take as an example, abortion rights. If Roe versus Wade is overruled, then it's likely that abortion will become illegal immediately or quickly in about half the states. And in those states, it's unlikely there'd be state Supreme Courts to interpret state constitutions to protect reproductive freedom. Or take the example of marriage equality. I regard marriage equality as one of the great triumphs of state constitutional law in recent years. We may too easily forget that it was the Massachusetts Supreme Judicial Court in 2003 that under the Massachusetts Constitution first found a right to marriage equality for gays and lesbians. Advocates for marriage equality intentionally chose to litigate in state court under state constitutions to keep the matter away from the federal courts and the Supreme Court. There was a loss in New York, a unanimous victory in Iowa, victory in California. And then only after these successes did lawyers go to the federal courts and had come to the United States Supreme Court. It's astounding that in a mere 12-year period, we went from the first decision of a state Supreme Court to the United States Supreme Court recognizing a right. But what if the Supreme Court hadn't recognized such a right? What if the Supreme Court, with its new conservative majority, were to overrule Obergefell versus Hodges? I predict that a number of states would then prohibit same-sex marriage, and a number of state courts would affirm such laws. And so there is an inherent ineffectiveness to state constitutional law as a way of protecting rights. It's not going to work everywhere in the country. Hard to imagine many issues where you're going to get all of the state Supreme Courts, including so many states where state justices face electoral review, including in partisan elections, where they will protect those rights. So I understand that today is about celebrating the 60th anniversary of Alaska statehood and a little more than the 60th anniversary of the Alaska Constitution. And I guess my bottom line for this to start the day is there's an enormous amount to celebrate. Thank you so much.